So we have a distinguished panel. Andrea, I'm just here to keep everyone calm. You have the floor.
Andreas, thank you very much. It's a real pleasure to be here, and I think it's a testament to Andreas' successful tenure in Germany at ICN that he manages to put together this type of event. I think having senior politicians, enforcers, business, private sector, and judges in the same room is really critical to the success of what we're trying to do. I think all of us who have experience of heading agencies know that outcomes are the result of multiple ingredients, and what we do ourselves is clearly quite important, but the overall environment, both the political context and the relationship with the judiciary is really critical for that. So I have a great panel here. You know all of them, but let me just go very, very quickly. So Jonathan Kanter, who heads the Department of Justice in the US. Cristina Caffarra, who needs no introduction, has been one of the leading practitioners in Europe and globally for many years. Benoît Coeuré, who has started a few months ago, leading the French Competition Authority. Fiona, whom you have seen on the panel before, who teaches at Yale. Olivier Guersent, who runs DG Comp. And Ingo Brinker, who is the senior competition lawyer in Germany and the chairman of the Competition Lawyers Association. So we try to discuss a few themes. We have quite a few speakers, so we try to go quickly around and trying to keep this panel dynamic. And as I said, I think, Andreas, you're putting together a great event. I really enjoyed listening to Mr. Giegold and Mr. Schmeilin. I think that's exactly the right kind of interaction. So let me start a bit with the political angle first. And the question I would like my fellow panelists to think about is a bit their reflections on where we are on this complex interaction between the sort of politics and agencies. So in many ways, you can think on a spectrum. There is a traditional way of thinking, which is, politicians kind of set some of the broad policy trade-offs, and then we are, technocrats. We know what to do. We enforce the law. We choose cases, and we spend time doing cases and defending them in court. I mean, I think when you then run an agency, you realize that potentially you can be much more effective if you interact in a constructive way with politicians. I mean, obviously, I think the DMA is a great example of it. You can spend all your resources having these 10-year-long fights with particular platforms, or you can be an expert advisor to the parliament, explain the problems, explain why we need different legal tools, and essentially end up with a very important new piece of legislation, which is likely to have very significant impact in the years to come. Obviously, the more you interact with politicians, you become an expert advisor, the more you enter a slightly more political arena, which can create some problems for the agency. And I think, again, it was interesting, Mr. Giegold was saying, the Bundeskartellamt has this very strong reputation in Germany, and I'm sure some of it is about independence and the fact that the Kartellamt has been a very effective institution through various political cycles. So let me open up with the panel. I'm certainly interested in views from all of you on how you see it in your country and more generally, this kind of, your current interactions with the politicians, and particularly what do you think we should do, particularly in a context where obviously there is a war, we've had a pandemic, so we're clearly at a stage where politicians are under a lot of pressure. We have inflation, cost of living issues in many countries. So politicians are under a lot of pressure. How can we help and at the same time maintain a healthy relationship? So Jonathan, I don't know if you're happy to start.
Sure, and it's a real delight to be here and to see all of you in person, which is a welcome change. In the United States, anytime you hear the word political, there's a tendency to use it as a synonym for partisanship. And so, interestingly, antitrust and competition law in the United States is one area that transcends politics in the partisan way. there's just as much interest in antitrust support from folks on our political left and our political right. But when I think of politics, I'm really thinking more in line with policy and the conversation with the community. And so as a law enforcer, our job first and foremost is to make sure that we are enforcing the laws that have been written, that are on the books, and that we're following the facts and the law wherever they lead. But how we enforce the law, what issues we prioritize, really depends on what we're seeing in the broader economy. And to understand that broader economy, it's important, in my view, for us to broaden the conversation. And so we've made an effort to have conversations like this, which are extraordinarily helpful and valuable, but not to the exclusion of having conversations with, in the United States, the broader business community. And that business community is not limited to large businesses that might come to Washington to lobby, but it also includes small businesses. It includes farmers who are entrepreneurs in the agriculture space. It includes other stakeholders who care about the importance outside the business community in the broader policy arena, who care about competition policy. And that allows us to understand the environment in which we're enforcing the law, so that we can determine where we want to prioritize and make sure, which is something very important to me, is that our enforcement efforts track with market realities. And so rather than thinking about things in a theoretical sense only, it's important for us to broaden our aperture and make sure that we're thinking about the interests and the priorities that fuel our economy and fuel our ability to provide upward mobility for people in the United States and make sure that we're enforcing the law appropriately.
Great, thanks, Jonathan. Olivier, you've also very successfully navigated financial services regulation at a very critical time, politically as well. I mean, what are your reflections in terms of your current role and your experience there?
Well, thank you, and indeed it's good to be in person. In these days I was already partnering with Benoît in financial services, so it's good to be the both of us in competition now. When listening to Sven Giegold, who was also part of this adventure, I was thinking about what he said about the Bundeskartellamt and the Bundesbank, and that reminded me of a joke Wolfgang Schauble made to me in the beginning of one of these nights of negotiations. He said, well, Olivier, do you know the difference between a central banker and God? I said, no. And he said, well, God knows he's not a central banker. Well, and I hope people will not say the same of Andreas, me, and all of us, because competition law or competition policy is not something, floating in a vacuum above other policies. It's one of the policies, and of course with specific constraints. It's very transversal. It goes deep into, in a market economy, making market functioning, which is really the real basis, and this is a specificity. But for the rest, there is as many competition policies as you want on the basis of the same competition law. Just to give you an example, in Europe, when we issued Regulation 1/2003, 15 years ago, we completely changed the way we see the Balancing Act in Article 101, because we decided to align the standard in 101.3, onto the efficiency defense standards in mergers, and to import that as an objective justification into 102, so to have something fully consistent. Well, the paradigm before, under Regulation 17, was the Balancing Act between micro restraints to competition and macro benefits. Is it policy? Is it political? Well, both, really. It is very political. And part of the questions we have now with the interaction with environmental law as environmental challenges, as Andreas emphasized in his opening remarks, are at the core of this discussion. How do you deal with out-of-market efficiencies, etc.? We have had heated discussions within the ECN, and we finally found a balance. That's policy, and that's political as well in the highest sense of it. Not partisan, as Jonathan said, but very political. Back to financial services. Well, it's a very good example of interactions. We have a small idiosyncrasy, as you know, is that we control state subsidies. But in the field of state subsidies, the interaction with the regulatory framework and regulatory enforcement, for example, in bank resolution, is still today a very big issue. Because, of course, the two needs to work seamlessly together. So there is no such thing as a complete isolation of the antitrust authority in making a decision in this, because it needs to work with the rest of the system. Otherwise, the system is broken. And that's very important. But there are other fields in which this relationship exists. I'll leave it to Benoît to develop, because he has had first-hand experience in this. So my view, in a way, is that competition policy interacts with basically all fields of the political spectrum and the policy spectrum, in particular network industries. That has been historically the case. And the speech we just had before the coffee break is very illustrative. You need to have the right regulatory setting, usually competition inspired, and then competition policy is there to make competition happening within that regulatory setting. And if there are flaws in the regulatory setting, point at them and try to get them fixed.
Yeah.
And in a way, because digital is such a big network industry, there's no mystery that this is very big, this interaction in that field.
Yeah. Thanks a lot, Olivier. Benoît, also you have tons of experience of independence, political pressures, lack of political pressure.
Yeah, thank you, Andrea. And first of all, I would like to thank very much Andreas and his team for putting together this conference at a time where international cooperation and international dialogue are more needed than ever. So thank you for doing that. So Andrea, you're asking me how it feels to move from being a central banker to an antitrust enforcer. So it's a kind of a reincarnation, and it's not yet too clear for me whether it's a reward or a punition, but I'm here to find out in a way. And Olivier mentioned his past as a financial regulator, and also Sven Giegold was a financial regulator. So, and I'm also not too sure that competition being kind of taken over by financial regulators is such a good news. I mean, given our success in achieving financial stability. So, but also here, history will tell. Well, I mean, to answer your question, Andrea, there are two things I learned at the ECB on what it means to be an elected bureaucrat. The first thing is independence is very much in the eye of the beholder. That is, people will be happy, will praise your independence if you do what they like, and if you don't do what they like, they will say that you're just another unelected bureaucrat, and you're probably too independent. And so I think that's common to competition and central banking. And the other lesson I learned is that it's sometimes the same politician who blame you for being too independent and being unelected, and who also would like you to do more. That's something I learned at the ECB. They want to be able to blame you, but they are all too happy that you're doing you're doing their job and you're taking the blame. I don't have such an experience yet in competition, but I fear it may happen at some point. And I guess the best protection is to focus on what you have to do. I think we need clear political mandates. I think we need clear assignment of tasks between competition authorities and other regulators, and also politicians. So we can call it Ordnungspolitik if you want, because we're here in Berlin, but I guess the economists in this room would call it the Tinbergen principle, and it amounts to the same. You need to allocate the right instruments to the right tasks, and to resist hubris, to resist the temptation to reach out too far and extend your mandate without political consultation. And yes, all issues are intertwined, and I very much subscribe to what was said on the first panel, that of course there are crucial interactions between competition and privacy, obviously, between competition, and competition can support the fight against inflation. I use support because I agree very much with what was said on the first panel. It can only support, but it can support. Competition can also support the fight against income inequality, wealth inequality, labor market outcomes, fair labor market outcomes, and so on. But you've got to be clear on who's doing what. So you need a clear assignment, and that kind of overall discussion can only be held at a political level. So just to give you two examples, first example taken from the first conversation on structural measures against systemic platforms. Yeah, well, that might happen. It happened in the past in other industries. It could happen in the future. So it certainly should not be kind of discarded and taken out of the discussion. But there are so many cross consequences in other areas, like what do you do on taxes? And you have this global discussion on digital taxes. What do you do in terms of the labor market consequences? What do you do in terms of data location if you want to break a systemic platform, and so on? And so you've got to think it through very carefully. And I would argue that's not a decision that a competition authority can take alone in a kind of lightheartedly overnight without thinking through the consequences. And so you need a lot of consultation with other authorities. And the second example is between competition authorities, is on the line between competition authorities and industry regulators. And not everyone may agree in this room, but I think we should resist very much the temptation to ourselves become industry regulators. And there is such a temptation. And the fact that we've been using very much interim measures against, particularly against digital platforms, kind of opens a kind of a slippery slope, which can lead us into becoming an industry supervisor. I've been spending a lot of time recently on one important case that we have to deal with in Paris, which is between Google and publishers, neighboring rights. And we are doing what we have to do, and there are measures to be, you certainly need measures to be taken and the market to be organized differently if you want to protect copyright and to protect the rights of publishers, and we're working on it, and we might soon come to a conclusion. But I don't want the Autorité de la Concurrence to become a press supervisor. That's not what we do, right? So I may very well come out at the end, whatever the decision taken by our college. I might come out publicly and say, okay, that's what we have decided to do in one particular case with one particular company, but please turn it into national law because we want this framework to be sustainable, and we don't want to be in charge. Or maybe Olivier wants to take it as part of DMA enforcement, and that will be his role, right? To decide if the new fund clause in the DMA will apply to publishers' rights. That's entirely yours and Margaret's call. But what I'm saying here is be aware of your limitations, and particularly at a time where the environment around us, the political environment around us is shifting. The political and the social fabric in our democracies is wearing very thin. So this is not time for us to take decisions without political preparation and without political deliberation.
Yeah. Great, thanks, Benoît. Cristina, you've been very vocal on a number of these discussions about the kind of where we are in terms of sort of historic under-enforcement and what we should be doing. I mean, what are your reflections? I mean, obviously you are less at the cold face of the politics versus agency side, but I think from your angle, how do you see things?
Thank you, Andrea, and thank you for inviting me. I should, as a private sector speaker, always disclose my conflicts, but frankly, after 25 years at the cold face, on the other side, there are very many. And you can find them on multiple websites where I put them all out. So I want to go back to something that Benoît just said. We shouldn't be perhaps too ambitious. I take actually the view that it is time to be very ambitious for antitrust agencies. It is time to come out of the shell. And I want to go back to something that you, Andrea, mentioned at the beginning. You were juxtaposing, you were saying the traditional theoretical model sees the independent competition agencies with officially technocratic roles with specific objectives that they're pursuing and elected politicians making the trade-off. But I would want to question that traditional view as being really the one that we should continue to be looking at. We are at a moment of incredible reflection globally as to what it is that we're doing. That view implicitly implies or supposes that actually the specific objectives that the technocrats are supposed to be pursuing are deliverable and measurable, and we've actually delivered on them. And I think this is not so. And it, in fact, is the case that the technocratic role make it even more difficult to ensure accountability. Politicians have a vague idea of what it is that agencies do. The public has no idea. Citizens have no idea, and this is an issue. And I think much of the current upheaval is certainly also driven by a notion that there needs to be more accountability, that people need to understand what it is that is being pursued. Because, in fact, if you look at the aggregate measures, they're all pointing the wrong way. I mean, let's not delude ourselves. Concentration is up, margins are up, prices are up, efficiency is down, innovation is not where it should be. So exactly what it is that these technocratic roles are capable of delivering and we can measure. So I think to me, we are at a moment of major upheaval, and that's because we haven't delivered. And this takes a fairly convulsive form in the US, and Fiona has already talked about it. There's this massive discussion about the consumer welfare standard, which is completely beside the point. There is this discussion about the original purpose of antitrust. Every conference you go to is we are about dispersing economic power. We are not about just doing technocratic little things, making agencies more accountable and so on. So Europe is somewhat different. It's not in this convulsive state, but we are questioning what it is that we're doing in antitrust, whether the objectives are actionable, and we've delivered on them. And with all the good intentions of the regulators, there's also, I think, a moment of self-reflection for me and other economists. We need to reflect on the role that economics has played in all of this. There was a funny Twitter exchange over the weekend with Josh Wright saying the self-hating economists who support the Brandisian. I'm not self-hating at all. But I think that there is no question that when you look back 25 years ago when I started in this, economists came into this with the ambition to introduce some structure, some rigor into antitrust that was at the time complete blanc mange. It was a soft discipline. Then economists came in, Chicago School, we brought in some nice things, but it is also the case, and let's face it, that the practice of economics in antitrust has become commoditized, has become pulped. You have this little vertical arithmetic here, you have a little hold-up story there, you have a little bidding study there. This is the diet that agencies get all the time. This is what they have to deal with. And we, frankly, have not been innocent in all of this. The community has not been innocent, because lawyers have figured out that if I get this economist who will say this kind of pulpy thing, I can kind of advance the case of my incumbent defendant. So this is a drift that has taken place. To conclude, I think this is absolutely time that we realize that this very narrow, technocratic, we shouldn't be ambitious, we shouldn't be just doing this thing, view of antitrust is conflicting with the political economy. The political economy situation is acute. Where is everyone living? So I think it is all very well to say, well, competition agencies need to do the narrow thing that they do. But we cannot not look at the fact that there are concentration levels, that there are problems in labor markets, that there are issues of the pace of innovation, that we're not dealing with killer acquisition or reverse version of it. So there is a significant set of issues that are urgent. And we shouldn't be just saying we shouldn't be ambitious, we should leave it to others. I think it's time to take some of these things on board. I'm not saying that we pursue inflation through antitrust. We don't pursue data protection through antitrust, but we need to get these things together, or we're lost. We're just kind of piddling. We're not doing anything.
Thanks, Cristina. That's really interesting. So Fiona, are you pretty much in the same place as Cristina, or do you?
Oh, she wouldn't say that.
Or are you going to draw some distinctions?
Thank you again for the invitation and for all the work that's gone into this conference. No, I would draw a couple of distinctions. I would just go back to your original question about, does the competition authority help advance legislation when they see a problem in enforcement? And I would actually disagree with Jonathan. I think on the right in the United States, there's substantial objection to competition enforcement because that lowers corporate profit. and delivers higher wages and lower prices and better quality and more innovation and lower income inequality, and that's not the agenda of our conservative end of the political spectrum. So, and also in the United States, we can't legislate anymore functionally because the country is so divided. So you don't really have the ability for an FTC or a Department of Justice to advise government on what legislation to bring, because it's just not going to happen. You can have things like the executive order, Biden's executive order on all of government competition, making competition policy in other places. This is very welcome because we have competition problems generated by the Department of Transportation, the Department of Agriculture, the FDA, and so on. Those would be great to fix. So that's a place in which there really is input by competition authorities into the rest of government. On the topic of economics, let me just say my own position is that the movement, and I'll just speak about the United States, the movement in the United States that wrapped itself in the banner of doing economics was really just the anti-enforcement, markets will self-correct, we don't need to do anything movement. And they describe themselves as doing economics, but in fact they do not. They rely on market self-correcting. Obviously you don't need to enforce if you think the market's going to self-correct. There's in fact not much role for antitrust at all in that world, and that's exactly the conclusion that those people come to time and time again. So I would say if you looked among academics who are doing actual research, we study markets that are imperfect, and there's absolutely a role for policy and absolutely a role for competition enforcement. And those people have considerably different insights and views on how you can use economics to promote competition and do enforcement that's helpful. And so I just urge this audience, which I know is primarily lawyers, to appreciate the difference between economists who are being paid to say certain things and or ideologically have an agenda that is against enforcement, and the broader spectrum of research and findings in the literature, which is quite different.
Yeah, no, that's very helpful. Thank you, Fiona. Ingo, what do you make of this discussion so far?
Yeah, it's always difficult to speak after Cristina, and I'm very grateful that Fiona took the role immediately after her, and that I'm only second in row. I may, if you allow, Andrea, would like to start by thanking Andreas Mund again for inviting us. That means the Association of Competition Lawyers and Economists, the Studienvereinigung, for being part of this wonderful conference and then being here on the panel. Like Cristina, I can say that we are not following certain interests because there are so many members and friends from the Studienvereinigung here in the room with very different interests, so I have to balance all of them to the extent possible. Having said that, what I would like to contribute is, and maybe it's time for the practitioner in private practice to take the role and to defend to a little bit the technical enforcement of competition law. Because at the end of the day, leaving aside politics, for example, for instance, and also the expectations from the public, what is in the foremost interest and also the responsibility of the authority is to enforce the law. And the law of the land as it stands, either in the black letter literature and also in the statutes, and not taking the role of the legislator. So what Cristina has said, and I fully agree with her, there are certain topics which have become topical in the sense that they are more dangerous. So if you take killer acquisitions, for example, I fully understand what she's saying. On the other hand, is it really the role of the authority on the basis of the applicable law to invent new standards, to think what can be done on the basis of the existing law, or whether it's the responsibility and the obligation of the authority to apply the law as it stands. In my view, with regard to the democratic process, it is very much to the politicians, to the legislator to decide what to do with these pertinent problems. You will say or may say that this will delay the process. Yeah, so be it, but we are in a democratic society, so we have to accept that there are certain roles, that there are certain responsibilities, and therefore I I submit that the authorities take their role, that they have to consider innovative approaches to the application of the law. But when it comes to new regimes, new systems, and new solutions like the DMA, like other pieces of law, then it's not up to the authority to consider that, it's up to the legislator.
Great. Thanks a lot, Ingo. Just to follow up to that, in terms of the transparency of these interactions between politicians and agencies, so I mean, in our case, in the UK, there's a very strong focus on independence of the authority. So what happens is we get a strategic steer from government, usually once for each parliament, trying to give us some general guidelines in terms of priorities. And then most of the exchanges are by way of essentially public letters that we publish on our website. So for instance, we're asked formally by the government to advise on possible digital legislation. We submitted the advice, we published the advice, so on and so forth. So it's a system, you know, I inherited, and it seems to work well for me. I'm just interested in the way it works in other countries. So I don't know, Benoît, maybe if you want to start first, because I think you were mentioning that you like the idea of having some kind of guidance and mandate. I mean, is that a similar thing that in a sense you think there should be some kind of written letter or mandate from the minister of the day to you that is public knowledge, is published and people are aware of it? Or, I mean, how do you see the split between this kind of formal exchanges versus, you know, a monthly meeting or whatever that you have with the relevant minister, but that would be in private?
Yeah, that's an important question, and well, certainly the answers have to be different across jurisdictions. I'm certainly not asking for guidance on, you know, which decisions I should be taking or my colleagues should be taking. That certainly would not square well with the concept of independence. So we have to be independent, and to protect our independence. We also have to be, since we are independent, we also have to be legitimate. And I guess that what political scientists would say about legitimacy, that it's both input legitimacy and output legitimacy, right? So output legitimacy is about taking the right decisions. It's very simple to say, very difficult to do. But in particular, that's about using all your instruments. And if there is any legal instrument that you're not using, you should give it back in a way. You should tell Parliament that it has been a waste of time and work harder to find the right one. So we've been active. We had that philosophy to be active using all the instruments we've been given and trying them. And that may entail some legal risk. I know we're going to come to that later in the discussion. But I think that's worth taking, because we have to be kind of faithful to what the Parliament has asked us to do. And if they've given us some tools, we've got to use them. So we've been active using interim measures, for instance, as a way to act in the digital field, and the new instruments given to us under ECN+, we're going to use them as well. So that's about output. But input is also about having a decision process which is robust and which takes account all, which is diverse enough to be robust and resilient. And that includes input from politicians. So you've got to talk to politicians and listen to them. And you don't have to do what they would like you to do, but you've got to be mindful of what they are trying to achieve and what's the general state of what are the expectations in the body politics in your country. So you need to meet relatively often with politicians to be aware of that. And I would rather keep it informal, just to listen. And that's just certainly not to be given instructions. But you also need a decision process where other stakeholders can have a say. So for instance, and I'm coming back to the issue of interactions with industry regulators, you absolutely need a decision process where industry regulators can have their say. So in France, we are mandated by law to consult them. For instance, we've consulted the privacy authorities like CNIL on the iOS case, and the new user requirements set up by Apple in their Apple Store. We sought formal advice by the CNIL. We've also sought a formal advice by the media regulator, l'ARCOM, on the merger between the two TV channels, TF1 and M6, and so on. And it's even better if it's enshrined in the processes, because then you just do it. And And maybe coming back to what Olivier said about interactions with financial regulators, I think that's an interesting instance where what historically would have been an instance of conflict or diverging interest can sometimes also align. I mean, I think you would usually think of the relationship between competition authorities and industry regulators as a trade-off, because there are different interests. Society has different angles, different interests. And that's also why it's better not to internalize that kind of trade-off too early in the process, because that discussion has to take place in the open, right? And that's why I argued earlier that competition authorities should not become industry regulators, because you want that discussion to take place in the open, in the sunlight. That's one thing. But in some cases, interests can be aligned. So for instance, if you take financial regulation and competition, historically there has been a lot of fight between central banks and competition authorities over whether financial stability and competition would go together. Central bankers have been very hostile to the state aid guidelines during the financial crisis. They've been against the bail-in rules initially, and so on and so forth. So a lot of this was really seen as a trade-off. If you think now of the consequences of systemic platforms entering financial services, you may find more alignment than you would think. And financial regulators and central bankers have come to discover that market power could become a financial stability issue. Yeah. That walled gardens created by big techs could create liquidity issues, could create issues for the functioning of the global financial system, and the discussion on stablecoins has been a case in point in that matter. And here you have alignment. So you've also got to be agile and follow very closely, what the evolution of market structures to understand when interests can be different and when interests can be aligned. And what's going on now in the digital sector is so powerful that in many aspects, interests are getting aligned. And so we can act together in the same direction.
Yeah. Great. Thanks a lot, Benoît. Jonathan, how do you see it from your side in terms of transparency of interactions with the White House? And
yeah. So I think when I think about transparency in terms of our enforcement agenda, I think there are a few different vectors. First is transparency with respect to our Congress. So our Congress writes the laws, we enforce them, but our Congress also has an oversight function. And so we have to, in a public setting, go up and answer questions from Congress. We get letters from Congress. And that's an important part of our separation of powers, and that happens all in plain view. But ultimately, the decisions that we make with respect to individual enforcement actions are our own, and they're based on the facts and the law. The same is true with the White House at the United States Department of Justice. We are part of the executive branch. And as Fiona mentioned, there are things like executive orders that give us direction. But again, the decisions that we make with respect to individual enforcement actions are our own, and they're based on thorough legal and factual analysis. There's the other vector, though, of transparency, which relates to the conversation we're having with the public. And that's something I referred to before, but I think I keep coming back to it because to me it's extremely important, which is that the detailed policy technical discussions can be very valuable, can be very important to understanding the facts that we're seeing, understanding market conditions, but it can also be very exclusionary, and as a result, lack transparency. And so if we're not having a conversation in a language that the broader public can understand, then we're not giving the broader public the opportunity to participate and to provide meaningful input. And if the broader public is not providing meaningful input, then we are going to miss certain types of market realities, certain types of effects that can be quite profound. And I think that's happened. And I think it's important for us to make sure that we are using a language that is not to the exclusion of expertise, not to the exclusion of nuance and sophistication, but in a way that's broad enough so that entire community can participate, because we have a lot to learn. The other piece that I guess vector for transparency is for us courts. So there are two ways for the law to develop. One is for Congress to go write the law or update the law, and that happens, but that's not within our control. We can provide input, and we've done that in some instances. We can provide technical assistance. We do that in other instances. But the way in which at least antitrust law, competition in the United States, law in the United States has evolved has been through an adversarial process. One where we go to a court and we explain to judges, to juries, our facts, and then we have decisions, and then the courts enshrine those decisions, and we can appeal them or not appeal them. That's a slow process, and the law evolves over time, but that adversarial process for us is extremely important to developing the law. And one consequence of not bringing enough cases, not testing that adversarial process enough, is we don't give the law the chance to evolve. And so one of the things that we've been focusing on is how do we get into court more often? And I think this may overlap with one of your future questions here, but we have to sometimes confront challenging judiciary, challenging legal precedents and decisions. But that's an important, healthy part of the process. And unless we invest the time and the effort to challenge adversaries in court, we're never going to bring the law up to date and make sure that it's fit for purpose in a modern economy. And so from a transparency perspective, that's extremely important, as well as from a legal development perspective.
Great, thanks, Jonathan. Just to finish off on transparency, I mean, Olivier, in terms of the very complex relationship, DG Comp, you know, you have the parliament, you have member states. I mean, do you think the system is broadly in the right place in terms of the transparency of input coming into DG Comp from the very complex ecosystem you're navigating at an institutional level?
Yeah, we are very complex and we don't trust each other. and for that reason, we're very transparent. And transparency is, and we do complicate it as well. And therefore, transparency is inbuilt in the system. I mean, frankly, the process in Brussels, or even the ECN, it's a glass house. I mean, you see through it sometimes we feel a bit too transparently, frankly. But it is important because we have our idiosyncratic institutional setting. I mean, the relationship with political appointees in my case is very clear. Mrs. Vestager is my boss, and she is a political appointee. It's not so extraordinary either, because Jonathan is a political appointee as well.
Did you just call me not extraordinary?
But I mean, let's not confuse political appointment with politicized, and this is what maybe the distinction between policy and enforcement is important, because you may have all sorts of ideas about policy, and one of other characteristics of the Commission is that we are making the policies as we are doing the enforcement. And as our judges recall us very, very often, we have a wide discretion when setting the policies, but once we have set one, we are very constrained in the way we enforce it, because we need to enforce it, I mean, in a non-discriminatory, transparent way, and they're very vigilant about that. So they acknowledge that the Commission, in that case, has a wide discretion when setting policies, but once you have decided on a policy, you need to live to it even when it's inconvenient. And be fair and transparent, non-discriminatory all throughout the case process. So this is where I think lies the distinction. You need very strong safeguards for the cases under the control of the judges, and that's the price to pay to have a bit of leeway on the policy, of course, which is not unlimited either, but okay. For the rest, I mean, I think there is arguably a lack of democratic accountability, not least because there is very little, if not no, competence of the European Parliament on competition policy. The member states have been very careful to reserve it to the Council, and I don't think there is any intention to change that anytime soon. But there is still, and I think it's good, pressure from the Parliament. I go to the Parliament Econ Committee relatively often. Mrs. Vestager goes several times a year, informal hearings, and they're not always nice, and that's good. And I think the way we compensate with this is two things. Well, first of all, we have the ECN, in which we basically, to a large extent, take collective decision about our common goods, because we all implement EU competition rules. And this is not really democratic accountability or counterbalancing, but bringing more people with more views around the table helps, in my view, having better and more balanced decisions. And the second thing we do is, I think, in terms of process, we're more transparent and consulting than probably anybody else in the world. Each time we make a policy move, we have a first consultation of the public, the general public, and the specialized audience, obviously. Then we publish all the answers. We publish a summary of the answers. We publish the line, what we draw out of these answers. Second consultation, impact assessment. And all this is fully transparent, fully available to everybody. And I think that's quite a big part of, if not the legitimacy, at least the credibility of the process.
Okay, just I want to link it back a bit to mandate and some of the comments. We, partially because of Brexit, when I started leading the agency, we had essentially a competition and consumer protection mandate. And then we have this markets regime that we've had for a number of years. And then over the last few years, we have added these new functions. So we're now policing the internal market in the UK as of last year. As of last week, legislation was passed to give us an advisory role on subsidy control, so the UK version of state aid. And then hopefully in future we'll get these kind of regulatory powers on sort of DMA type powers on digital. And so myself and the board, we've been quite open potentially to extending our mandate to some extent in the context of the type of discussions with politicians we've just been mentioning, because we think agencies naturally need to evolve and reflect the kind of needs of society. And I think personally there are clear synergies and efficiencies in running agencies that are bigger rather than have lots of small regulators which just do one particular function. But that clearly creates possible tensions because in a sense you start with this DNA of being an enforcer and then you become more and more almost like a player in the policy-making debate in the country. So for us it's a very live discussion as a board how this is going to evolve over time. So I'm curious in reflections from the panel on this point, this kind of trade-off, and I think maybe Benoît again, if you want to start, because I sense you are a bit in a slightly different place where you think there is probably the risk outweigh the potential benefit when you keep expanding the mandate of the agency. And I think, it's a judgment call, and I think all of us are learning from experience, but I'm certainly interested in your views on these trade-offs, whether, in a sense, we become better players in this kind of democratic economic policy debate by having more functions and more touch points, or whether there is a risk that essentially we weaken our core and we become potentially weaker enforcers by doing so many different things.
Well, I might be too much influenced by my recent past at the ECB, where indeed as I said earlier, I've learned that politicians may ask you to do more, but they will blame you anyway. So you might answer, then why not do more if they will blame you anyway, and that's the discussion. But I very deeply believe that some of the issues we are facing are issues which are not of a technical nature, which we can't paint as technocratic decisions that can be taken outside of the political conversation. Privacy, I think, is the best example. Privacy is a deeply political discussion. I'm not equipped as competition authority to deal with that, really. That has to be done in a different way. And then we've got to put the right structure on it and have the right kind of relationship with privacy authorities and with political authorities to discuss it, which we're trying to do very much, very hard. That's why I'm kind of reluctant to have the mandate being broadened too much. The Autorité de la Concurrence in Paris, it's 195 staff. It's not a lot. I could do with a few more. So if there is any French MP in the room, that's just, that's my message. But I also believe that being nimble and agile is something, has been an asset for us. And not having to deal with, vast troops of staff across France. And we are working very well with the consumer branch of the Ministry of Economics, the DGCCRF, to identify cases all around France and they are working on commercial practices. We are doing antitrust, and it works very well, actually. So I believe in that kind of focus and nimbleness. That said, I think we are all different. There are idiosyncrasies everywhere. So, for instance, in France, we've been given authority on collective purchasing agreements, because that has been a very strong focus in the retail sector and also in the farm sector in France, and so that's something politicians wanted us to do. We've been turned into somehow an industry regulator for legal professions, for notaries, for instance, because the parliament, I think, wisely decided not to create another independent authority just to do that, and so they entrusted us with doing it, and we're doing it. And I guess all of us have their different kind of, set of priorities based on national preferences, and that's okay. That's okay.
Yeah. Thanks, Jonathan. What's your view on mandate and potentially
Sure.
expanding your mandate?
Yeah. So I run the antitrust division at the U.S. Department of Justice. We're just under 700 people who focus only on antitrust, competition law. We exist in a broader institution, the Department of Justice, which is criminal enforcement, the FBI, environmental, civil rights, a broad range. And so, but the work we do is in our enforcement authority is limited to antitrust. That doesn't mean, though, that what we think about is limited to antitrust. So let me explain. First, I'm a big believer in interdisciplinary learning, and so as we think about the interaction, or frankly the merger between privacy and competition, the two run hand in hand. And now our FTC has privacy enforcement authority, but for us to understand an impact in technology markets, we have to understand data collection. We have to understand the benefit of the bargain between a platform and a consumer in terms of the data that's extracted and used. And so these are market realities that are fundamental. The same holds true in financial services and healthcare and numerous other areas. There's another piece of this as well, and this is something that we've tried to do and we're building out in real time, which is understanding competition policy and enforcement tools that exist throughout the government. Fiona alluded to this earlier in terms of our executive order. We've undertaken an effort to identify throughout our entire U.S. government, and including other agencies, tools that promote competition or competition enforcement, everything from our Federal Maritime Commission with the Shipping Act, or our Department of Transportation, which has an act that prohibits acts that unfair methods of competition, and a wide range. And so we're working, our Department of Agriculture has something called the Packers and Stockyards Act, which gives us the ability to enforce competition policy alongside our partners at the Department of Agriculture under certain circumstances. So we're working hand in glove with those other agencies to dust off those tools, to ensure that we understand them and make sure that we are enforcing them using our expertise and our resources, which I say are just under 700 folks. That's 350 or more than 350 fewer people than 1979. And so, to the extent that there are any folks from the U.S. legislator who want to give us more resources, or from French Parliament too, we'd be welcome. Well, actually, I just for the record, we will not. But just kidding. We in order to be effective at enforcing all of those other statutes and all those other laws, and we will need to build that out. We will need additional resources, but that's an area of untapped enforcement inside the U.S. economy, inside the U.S. government. And so, finally, we also have undertaken an effort to provide competition policy guidance and advice throughout our government. And a few examples here: our Department of Treasury issued a report relating to labor, and we provided substantial input there. We provided a lengthy statement to our Labor Relations Board about what we call misclassification of gig workers that deepen asymmetries of power. And so we're working very carefully and deliberately to identify those opportunities where we have distinct expertise that can inform other agencies. And we're finding open doors that other parts of government are eager to tap into our knowledge base, eager to understand our investigatory tools, eager to understand our expertise in order to incorporate competition policy. And this is something that has been very effectively furthered by President Biden's executive order, which mandates agencies to work together in order to further our competition policy agenda.
Yeah, no, I definitely noticed. I mean, we've been doing very much the same. So I noticed that you've really set a different agenda in that space since you started. So, Cristina, any views on mandates and trade-offs?
So,
I rigged it so that I would go before Cristina, which is always a safe bet.
So, if the question is whether it is a good idea for the mandate of competition authorities to be somewhat broadened, it is unquestionably a good idea. It is unquestionably because we need to sit back and say why it hasn't really worked as well as we hoped so far. Because that's the reality. It hasn't worked as well as we hoped. So what are we doing wrong? I don't think that latching on to a bucolic vision of antitrust law, which is pure, it's a church, it's the law, or another view of economists dreaming that they can provide some sort of science to this, is helpful. We need to just take a step back and say, why is it that this hasn't worked? And the reason it hasn't worked is because there is a lack of I think inevitably, I mean, the world moves on. Things need to be adapted, and there is incredible value that can be brought to competition enforcement by this. I mean, I agree very much with Jonathan. This greater attention to other disciplines. Take privacy, which is something which is super close to my heart. Look, can we deny that the fact that we are where we are because, in part, we have not been effective in dealing with the market power of the digital giants, and that has led to the kind of exploitation, extraction of data, which is at the origin of many of our concerns. And conversely, we haven't been very effective at enforcing that data protection because we have institutionally designed it in a way that effectively means this hapless data protection regulator have got to go and fight the giants with plastic knives. And it is the reality of it. So my practical suggestion is that we need to think back about some practical things. We need to rethink some practical things. One, I think, to my mind, we need to certainly constitute some multidisciplinary working groups to think about some of the big issues, which we don't have answers for. How do we deal with power expansion in ecosystem? Now, Andreas last week mentioned maybe we can talk about strengthening of ecosystem power. Good idea. Let's discuss it. Is it something we want to do? I like it. Let's discuss. We have this privacy thing. We have market power in labor markets and the connection between that and product markets. We have the whole issue of resilience. So far, this was industrial policy. We don't touch it, but we cannot have a view. So there's one. Two, we need to go back to presumptions. Now, this is a thing that it's strong to say in Germany. And I remember Andreas Mundt at my conference 4 years ago, perhaps, when I started to say maybe we should reconsider presumptions, said, Cristina, you economists told me all the time that we in Germany were wrong with our presumptions. And now you're telling me I'm hip, that I'm fashionable. And it's true. We need to go back to some rebuttable presumption because this case by case, every case is different. It's a little bidding study being counting, and the merger is okay. It's nonsense. It's really nonsense. And finally, we need to rethink remedy policy completely, because in mergers, we are not enforcing, we are not blocking, we are going forward with remedies that are completely ineffectual. We are not doing killer acquisition yet, because who knows, it's all very nascent. I mean, come on. And then in conduct, we don't do anything that's got any value. So what exactly is our remedy philosophy? So these are all practical things that I think need to be done one by one within antitrust, but with a broader lens.
Great, thanks, Cristina. Fiona?
Yeah, I think I agree that competition enforcement has not worked. I would say in the United States, at least, this was partly due to a lack of communication. And one of the things I love about the populist approach to enforcement, which we now have in the United States, is so much more communication. We have these laws, they're designed to protect the people, they're designed to protect competition. Tell us about it, we'll tell you about it, that your tax dollar is working for you by funding this activity at the government level. So I think that's a huge step forward. I think that another reason that we had lack of success is that the parties with market power found other ways to protect their market power, and they did that through an exemption for insurance from the antitrust laws, an exemption from shipping from the antitrust laws, a regulator like the Department of Agriculture that helped agribusiness and led us to a state where lots of farmers are experiencing the exercise of monopsony power and not getting competitive prices for their chickens or other products. So expanding competition enforcement to think about these other areas like subsidy control or like inside of agencies or advice to the government or the other list of things that Andrea mentioned, this is just, I think it's all competition enforcement, it's all competition policy, we're good at it, we know why we're doing it, and more, as we discussed earlier this morning, is very helpful because then you get these knock-on effects of combating inflation, combating income inequality, helping with democracy. So there's just no downside, I think, to expanding the remit as long as it involves something that we know about, namely the way competition should be analyzed and how to make things better. So I would say that that's clear, and I'm not really concerned about these kinds of expansions because they all seem very good to me. One last point on remedies that Cristina brought up. I think that is, to me, watching from the outside, the big challenge for Europe. I think in a world where, especially a digital world, where there are network effects and the winner markets tip and you suddenly have a winner, the payoff to doing some anti-competitive stuff for a few years so that you become the monopolist for 10 or prolong your monopoly for 5 is very, and when you think about the billions of dollars that these platforms earn, that potential profit is very, very large. When we think about the kind of fine that you would have to deter in expectation that profit, so if I'm going to make $10 billion, but I only have a 1/3 chance of being caught, the fine has to be $30 billion. Okay, this starts to be the level of fine that courts are not going to be comfortable with. And so if we're going to be, well, I think you should be able to multiply and the fine should be what the fine is to get the job done. But I don't think that works in the system we have, which means that other remedies really have to be considered, and those might be interim measures, but in particular structural kinds of solutions like divestitures. And also, I think, and the DMA takes a step in this direction, interoperability requirements. Okay, you got your monopoly in a way that we think violated the law. Now it's too late. How do we cause there to be competition in that market? Perhaps mandatory interoperability is a solution. But these are going to have, I think this is the big challenge, is getting remedies to actually restore the lost competition instead of being a cost of doing business and being a tiny fraction of the profits gained by the conduct.
Yeah, thanks, Fiona. I mean, Olivier, you are actually in the midst of getting a bigger mandate with the DMA and hopefully more resources over time to do that. I mean, feels like a big new job on top of everything else you're doing. I mean, what's your view on it?
Well, it is indeed. Well, first, I'd like to welcome Cristina in the community of lawyers with certainties. After years of being a normal economist with doubts on everything.
You see, experience does that.
Yeah, that's good. But I mean, beside the point that I don't think we were so much under enforcing in the Commission, particularly on digital, these last 20 years. At least if we were under enforcing, see Philip Lowe in the assistance. I mean, I remember the Microsoft case. Everybody were telling us we were crazy. And again for Google Shopping.
Yeah, I would say it's for me, my remarks, just so they're not misunderstood, I think in the US, we were under enforcing.
No, I didn't,
Yeah.
no worries.
Yeah.
But I mean, what I mean to say is that there is only a pace at which things can go because of cultural reasons. And the culture has always been different on both sides of the Atlantic, so that's partly why it went at different pace. And there are things that, for as much as they are desirable and probably, I agree with Cristina, could have been or should have been done before, it's simply impossible because the state of mind of people is not yet there. And rightly or wrongly, you believe it's not possible. And the conditions are not there to do it. I don't think we could have done DMA 5 years ago. I think it would have been good, though. But I don't think it would have been possible. It was challenging enough to do it now, frankly.
Yeah.
Because to justify it, we needed to demonstrate that throughout all these years, I mean, what you said, Fiona, is exactly right. I mean, because, and for good reasons, rights of defense, I mean, complexity of the investigations, and I still believe, Cristina, each case is different and needs to be investigated on its own merits. So all these things take time. So you need 2, 3, 4 years to come to a final decision. And with the network effects that are prevailing in these markets, competitors are dead after 6 months. And they're dead forever. So it pays off. And the DMA is simply, well, as we have no means to cope with this within antitrust,
Exactly.
move on to ex-ante regulation.
Yep.
But to do this, you need to have a consensus. This is not at the hand of competition authorities. I go very much with what you said previously, Ingo. This is at the hand of the legislators. Because that's only they have the democratic legitimacy to bring such a step change. And back to the DMA, well, I think it's very good. It will have its own challenges. Again, of course, staffing would be one of them. But I think the stakes are so high and the credibility of us collectively also that what is necessary will be done. Also, I think we have crafted a quite good system. Andreas referred it a bit in his introductory remarks of trying to pull together the DMA. The DMA, I mean, had to be at the level of decision and exclusive competence of the Commission because simply the footprint of these practices is at the very least Europe, most often more than Europe. But I think it will be good to be able to design enforcement strategies together, playing with national instruments, EU traditional antitrust, and the DMA, because I believe strongly that in that field, it would be good that we agree on how we play our cards sequentially so as to reach the best outcome. So I think it is very welcome that the co-legislators decided to kind of enshrine this coordination mechanism within the ECN. And I think it would be a big responsibility for us collectively to make it working, because that means we will have to leave our institutional egos at the door.
Yeah.
You know, because if we have a tough battle about my case, your case, we're sunk.
Yeah. Thanks, Olivier. Yeah, Ingo?
Yeah, I would like to add perhaps 2 observations, maybe 2 different ones. First, I would join the rest of the panel in saying that there is maybe a room for expanding the responsibility of the authorities, but I would plead for a rather measured approach in the sense that it shouldn't be everything that should be covered. I think the strength of an authority of a competition authority is enforcing competition law, having built experience in economics, in the legal questions being developed in the context of mergers, cartel enforcement, and so on and so forth. So a measured approach. We are in this country at the moment at a restart of thinking about expanding the Bundeskartellamt's responsibility for consumer protection, which I believe is a good thing. We have seen here in this country tons of cases, small cases in private enforcement. All of them are important. All of them are published, so they are publicly available, but there is no political message in this context. So I guess the large cases, the cases below dominance, maybe below Pickham under 19A nowadays, these cases may deserve a more experienced approach in the sense of exercising investigative powers. It's not so easy to enforce. You know that much better than I do, but it's not so easy to make use of enforcement powers and investigative powers. So my pleading would be a measured approach. Yes, there is room for expansion, but be careful. The second one is, if you allow, Andrea, fairly different. I tried in my first intervention to make the case of a pretty technical application of the competition laws. And this has a very practical reason, and please forgive me, I'm a lawyer in private practice, like many others here in the room. We have to advise our clients. We have to make clear what is the schedule, what is timing, what is the predictability of transactions in merger cases. So if we have a broad spectrum of various parameters which have to be considered, newly developed, it will be difficult, to say the least, to advise properly on those transactions. So I think the merits of the activities of the authority over the last decades also has been that it is, I wouldn't say easy, but nevertheless it is possible to predict to a certain extent the outcome of a merger case, for example. In this context, I would like to contradict a little bit this notion of under-enforcement. Clearly, Olivier has correctly said, we have seen a number of 1 or 2 cases successfully brought by the Commission, by DG Comp. It's taking a long time, but it's difficult because the companies, of course, are able to defend against any allegations, but they have been successful. The Bundeskartellamt and other authorities in the world have been successful as well. So under-enforcement, I think, is maybe not my kind of perception. But my pleading is competition law enforcement should be predictable, remain predictable to a certain extent, because the undertakings simply depend on the authorities. And Andrea, if you allow me one final remark going back to transparency, because that is also quite important. All what you've said, I fully agree to that, but there is one aspect which has developed over time quite successfully, in my view. Some colleagues would challenge this statement, but communication. This has developed successfully and also extensively over the last decade, maybe 15 years or so. We've seen press releases. We have seen statements of senior officials of DG Comp, of the authorities. We've seen press statements. We have seen interviews explaining to the public what has been done by the authorities. I think that's a good thing. It's a good thing in the democratic process. It is also very helpful because the application and enforcement of competition law is complicated, it's difficult, it's complex. It's not easy to be understood by the public who are not dealing with competition law every day. So communication is important in this context and also contributes, what Olivier said, to transparency.
Great, thanks, Ingo. Andreas, should I finish now? Do we have 5 minutes to the final? Yeah. Okay, so literally 1 minute at most each. Any reactions to the other comments? But also one thing, if you can bring it in. I mean, one of my anxiety is that I feel sometimes the judiciary is not sufficiently involved in some of these discussions. Now, I think today is really an exception. I think Andreas very successfully has some of the senior judges in Europe today in the audience. But I mean, at the end of the day, there are judges who play a major role in competition enforcement, big decisions, and obviously we all strongly believe in independence of judiciary and division of roles and all of it, but it seems to me it would be helpful potentially as a community to have a bit more of a dialogue, obviously fully respecting our roles. I mean, are we missing a trick a bit on that in terms of not inviting judges to be on panels like this one, just to have some of these more policy-type discussions, so completely independent of specific cases? Because to be honest, my perception, certainly in the UK, but I think it's the same in Europe, we now bring slightly different cases with slightly different narratives, but the discussions in court is still very much the same we've had for the last 20, 25 years. And I think it's quite difficult for judges to kind of move on because, in a sense, they are just dealing with what their appellants put in and the reactions. So I just wonder whether we shouldn't have a bit more of that discussion publicly as well. So, Jonathan.
Yeah, and I'll start. I think actually your question relates to something that Olivier said earlier, which is that you talked about how the DMA would have been good 5 years ago, but it might not have been possible 5 years ago. I think a lot of that has to do with the nature of the conversation that's taking place and has taken place over the last 5 years. We're sort of in the middle of this transformation, and where new ideas have been infused, where we've had honest retrospectives on what's worked and what hasn't. And I think it's exciting to live in that time period, but it also means it's why, to me, it explains why it's important to have a critical conversation. It also relates back to something you were saying earlier about predictability. Sometimes competition isn't predictable. And I think our effort to try to come up with predictable framework, boxes on theories how competition functions, especially at a time when markets have transformed in such profound ways, has been a shortcoming. And sometimes effectiveness is ultimately going to be the most important measure. And if the law is effectively enforced, then predictability will follow. Finally, that leads to judges and courts. In our system, in many respects, courts are a lagging indicator because you have to investigate, you have to bring the case to a court, the court has to hear the case, which can often take, in our system, years, and then you have to have appeals. And so the courts are part of the conversation, but it's based on the controversies involved in each individual case. And the only way we're going to give courts the opportunity to shift is if we give them more opportunities to hear cases. And it's our responsibility to communicate market realities, market changes, and theories to courts in a way that's digestible for a generalist court. And the law allows for that. It just takes time, it takes courage, and it takes effort. And that's our responsibility.
Yeah, I agree. Cristina?
So I wanted to pick up on the question of under-enforcement because, of course, I understand Ingo needs predictability. Everyone in this room does for the clients. But the point really is, when we're talking about under-enforcement, it's not about intentions or effort or goodwill. Everyone recognizes that agencies have done the best they could at the time, often in the circumstances, but the outcomes are what they are for a variety of reasons, because things were not possible to perhaps be done differently, because remedies were ineffective. Whenever I go to the US and talk, I'm a great defender of the European Commission's effort on Google Shopping, on Google Android, on Google AdSense, because I think those were good cases. They were good theories of harm that are absolutely robust. And yet, when you look at the situation on the ground, unfortunately, we haven't shifted. Nothing is shifted on the ground. And the commissioner hasn't recognized it. She said, if I had my time again, perhaps I would do it differently. So this isn't about bad will or laying blame. The fact is that the outcomes are not favorable. And so that's the notion of under-enforcement that I think we are staring at in the face. It's outcomes. Now, on my 2 cents on the judiciary, I think, of course, I have a European perspective. Judges, of course, perform this incredibly important role, and they have shown that they can really pursue some pretty forward-looking sort of notions. The Google Shopping judgment from the General Court says basically self-preferencing is a thing, okay? Notwithstanding the fact that people have tried to deny that it was. It is a thing. So the Google Shopping case is one in which the judges certainly have embraced certain ideas and supported the commission. There are other cases which have a chilling effect, and that is something that judges really need to internalize, because cases like Intel, cases like judgment like Intel or H2 or H302 have a chilling effect. I know for a fact that when it comes to talking to regulators about mergers, and blocking mergers, they say, but we have the 023 judgment, and this is really chilling for us. We don't want another fighting court of that nature because the judgment has been very adverse to us. Similarly on Intel. Basically, Intel seems to be spelling the death of price-cost tests at this point. And so I hear regulators saying, oh, we're changing this case. We are not going price-cost. We're going to another direction because price-cost, we were killed. So I think that is a great responsibility that I think needs to be taken into account. And indeed, you know, as others have said, the discussion needs to advance, even involving the courts.
Yeah, thanks, Cristina. Benoît?
Yeah, two things. I mean, first, I very much agree with other speakers that the advocacy role of competition authorities is absolutely crucial. You said, Olivier, that sometimes it's not the right moment, right? Because the conversation needs to crystallize somehow in the public space, and it hasn't done yet. So you can help. So you can help. You can put structure on the discussion. You can explain what's going on to the public, not only to politicians, but to the public at large. By the way, Mr. Schwemlein earlier in his excellent speech mentioned the Macron coaches in France, which were decided back in 2015. That followed an opinion issued by the competition authority on opening the market for coaches. And in that case, it took like a couple of years for politicians to act. In another example, which was about the market for car parts and opening up the market for car parts, it took like 11 years for politicians to act, but they've acted. So far, so good. Sometimes you need to be patient. So that's extremely important. A second thing on judges and courts, in our own experience, I think the French judges, particularly the Court of Appeal, the Paris Court of Appeal has, on average, well understood us. I mean, particularly when it comes to digital. We had our first case against Google back in 2010, I guess. That was the Navix case. And in 2010 also, we issued an opinion on online advertising. And they've, on average, mostly upheld what we wanted to achieve. Recently, the Court of Appeal has also upheld the Google Give Media case, and also our interim measures against Google on publishers' rights, which I mentioned earlier, the 2020 decision. So far, so good. It may change in the future, of course, and we have to respect that, but so far, so good. But the only thing I wanted to add is that it's not all about us. It's not all about competition authorities, and there is a lot going on outside our world. So you have standalone private enforcement. You have follow-on damage actions, and they're all kind of outside of our universe. And that's also where dialogue with the judges is very important to help them achieve consistency, to make them aware of what we've been doing, of the arguments, and so on. And my first visits when I joined the Autorité de la Concurrence were for the Court of Appeal and the Cour de Cassation, just to have that kind of discussion, Yeah. And it's with full respect to independence on both sides, but we need a conversation, of course.
Yeah, thanks. We're kind of out of time, so really very, very quickly, Fiona.
The courts are a major problem for improving competition enforcement in the United States. These are judges that are generalist judges. They're mostly hearing drug cases and other things. So it's not possible to educate them because there are too many. And they might get, well, I mean, if your chance of seeing an antitrust case is once in 10 years, you do not want to go to a week-long class on antitrust. It just doesn't make sense. Unfortunately, then they tend to rely on ideology rather than on becoming an expert when they see these competition cases. And this is a problem for improving enforcement. I think one issue is, of course, also that to become a judge, you're usually later in your career. Do you even use the products that are often at issue in the case? Perhaps not. And so I don't really see a path forward here other than time and social change and appointing new judges, maybe some who are younger, who have experience with the products that we all use. But this is, I think, the major roadblock in the United States to having substantive change in this area.
Thanks, Fiona. Olivier?
No, simply, I mean, we have a specific setting at EU level, and what I want to say is, on the one hand, it is healthy to have the judicial control over your head, because that forces you to think twice about what you're doing and what you're about to decide. And of course, the question, will it stand in court, is a very legitimate one. This said, I mean, sometimes you need to make the conscious choice to go beyond. This is, in a way, what we did in Google Shopping, for example. And sometimes you're followed by the court, and sometimes you're not. So there is a kind of dialectic relationship. We learn from the court rulings. We learn from the conclusions of advocate generals. We think, and then we try to move forward. Sometimes the judges follow us, sometimes they do not. But I see the system as bringing a healthy discipline and kind of collective thinking. Now, about having more judges on, well, I've made many numerous conferences with Mark, so I can tell you judges are not in general shy from participating in conferences, but they're rightly, I think, wary of not being captured, not being seen as too much involved into the public debate while they have to make their ruling, and I think that's fair. Yeah. So, but just to conclude, so what is good is that sometimes it is unpredictable in the
So Ingo, you have the final word.
Oh, that's good. That's good. As a lawyer, it's always a privilege. I will limit my remark to the statement that at least in the European continental system, judges are simply limited by the cases which are brought to them. So if there is no appeal, there is no judgment. And I've heard Professor Kirchhoff saying that he would invite more cases coming so that he and his colleagues would be able to decide more cases. But if there's no case, they can't decide on that. They can't develop the law. I think that's a major limitation. I think it's just systematic and therefore the specialization of the courts, as Fiona has said, that's something that is different, at least here in the country, but also at the European level, that judges can contribute in case they receive a case.
Can I have one
John,
sorry,
so you're cheating, yes.
If we can't learn how to explain things to the broader community and the broader public, we're never going to learn how to explain it to judges. Yeah. And so I think really it does go hand in hand. It's part of the social change. It's part of the judges should be able to understand these issues, and it's up to us to make sure that the conversation is not so technocratic that it becomes exclusionary for a judge.
Yep. And you mean generalist judges in your case, because in our case we tend to have more specialized
in our
judges.
Case,
yeah. Great. Thanks, everyone. Please join me in thanking the panel.
Interesting.